This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about what happens when a jailhouse lawyer tries to get out of jail into an elderly house confinement program after being convicted of arson for profit that resulted in the death of a firefighter. Jack Ferranti, acting as his own attorney, probably because no attorney would even try, appealed the district court's order denying his petition for habeas relief and his motion to reconsider. Ferranti was responsible for causing a fire at his business that resulted in the death of a firefighter. The trial judge sentenced him to 435 months imprisonment. His conviction and sentence were affirmed on appeal by the Second Circuit. In Jack Ferranti v. Warden Allenwood, a United States Court of Appeal for the Third Circuit's June 30, 2023 decision noted that Ferranti was convicted in the United States District Court for the Eastern District of New York of arson, homicide, arson conspiracy, 16 counts of mail fraud, and witness tampering based on an insurance fraud scheme. The Third Circuit resolved the request for release to Mr. Ferranti under the Elderly Home Confinement Program, the EOHDP, and he asked the district court to order the Bureau of Prisons to process his application and place him in the program. In 2020, Ferranti argued that he met the criteria for the EOHDP, and he asked for the district court to order the Bureau of Prisons to process his application and place him in the program. Analyzing the issue, the Third Circuit noted that, as the district court had explained, federal courts do not have the authority to grant the relief Ferranti requested to order his placement in the EOHDP. The executive branch, not the courts, have control over an inmate's placement. Moreover, even if the ability to challenge the BOP, the Bureau of Prisons' actions, were available through habeas, Ferranti did not establish that he qualified for the program. The statute disqualifies those whom the Bureau of Prisons, on the basis of information the Bureau uses to make custody classifications, and in the sole discretion of the Bureau, determines to have a history of violence. Further, if he did qualify, the Bureau of Prisons would not be required to place him in the EOHDP because, again, the statute leaves placement as a matter of discretion for the Bureau of Prisons. In any event, the Bureau of Prisons did not err by concluding that Ferranti's history of violence, comprised of the underlying conduct for his convictions as well as disciplinary infractions in prison, qualified him from participating in the EOHDP. Ferranti, in an example of chutzpah, Yiddish for unmitigated gall, sought release from prison into an EOHDP in violation of the program's requirement that only a nonviolent prisoner is allowed into the program at the sole discretion of the Bureau of Prisons, just because he is elderly, especially after his arson for profit scheme resulting in the death of a firefighter was denied by the Bureau of Prisons, the District Court, and now the Third Circuit without hesitation. And Ferranti continues in his efforts to abuse the court system. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog, where you can subscribe to the blog post and receive every day, usually 5, sometimes 6 days a week, a blog posting, and have access to the more than 4,550 blog posts. You can also subscribe to the free videos on rumble.com and on youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And if you liked what you've listened to and what you have read, please tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you wish further detail on insurance claims, and insurance law, please consider subscribing to my Locals community or to my Substack publications. Thank you for your attention.